You can identify, right, you should, the website is at top. You can text 37607. So the text number is 37607. Once you get that number, you should type in the words Randy Waldema 222. All right, I got one person who started texting me. And only one person who started texting me. There are 105 of you. The text number 37607. To that number, type in Randy Waldema. All right, the answers are starting to arrive. Obviously, I made the poll, which is why delinquency is first.
But we're glad to see all the dependency attorneys.
And I ran out of types of law, so I apologize if I left your area off, and I probably, in looking at our list, should have put one for judges. Should have put one for policy. I did a terrible job creating a poll.
Randy Waldman made the entire PowerPoint as a caveat.
All right, so the vast majority of us, right, about 60% of us appear to be dependency primarily. That's good to know. I'll let Emma do all the talking.
Yeah, I'm ready.
I'm gonna close out this poll and move us to our next one, which is the questions we're really trying to answer. How much in-court time are you actually having right now? Are you going every day, JP Burlon? Are you going never, Randy Waldman? I have personally not been inside a juvenile courtroom in 1 year and 11 months. We are approaching my 2-year anniversary since the last time I was inside a courtroom. That appears to be, surprisingly, most of us.
Yeah.
I think that is a Metro thing. I don't know how many of us are Metro on this call. That appears to be a Metro thing. But yeah, about 70% of us aren't really going into court, which I think highlights the need for this presentation of what are we doing online and how are we doing it online. All right, my next slide is a word cloud, because I couldn't figure out how to create a poll that allowed you to choose more than one choice. In the word cloud, I want you to type in the type of hearing that is primarily virtual. You can type as many things as you want, but it has to be one word. So if you have a 2-word answer, put them all together as one word. And you can answer as many times as you want on this. So if you're doing 20 hearings and 20 different types of hearings, keep answering. What you might know is that the more times somebody types the same word, that word gets bigger. Right, so adjudication, reviews, PPHs, those are our most common hearings. I hate that adjudication is top on that list, but we'll get to that. Give this another minute or two. All right, people still typing. Let's cut off the answers here, but it does seem review hearings for sure, which makes sense. PPH hearings, disposition hearings, and adjudications are happening virtually. All right, I'm going to go to the next slide, which gets us to the question of, at what point should we be asking for a Zoom, right? In the world where we have a choice, what should our choice be, and why are we making that choice? So I have one more word, well, I have two more word clouds for you, but I have one more first, which is, in your own one-word answer, right? Again, combine words if it's a two-word answer or a phrase. What are the benefits of virtual court? Uh-oh. Apparently, I lost internet access, which means you're all typing wonderful answers, but I can't see them because I lost access. Nope, it says I did not lose access. I don't actually have an explanation for this.
Are we still connected?
Yeah, it says I'm connected. All right, I'm gonna start sharing again. Yeah, so for those of you who've already started doing this, go ahead and put your answers in the chat. Those of us who are in the room can't read your chat. Let's see what happens if I leave this. I swear it says I am still connected to the internet.
Internet connection log.
Yeah, but now I'm stuck. I can't do anything. All right, so I'm gonna stop sharing for a second, read these. Pajamas is the first one I came on, so good job. That is in fact, right, the best. More convenient, can get work done between hearing, better attendance, convenience, easier to attend. Credibility and formality, convenience, foster parent anonymity, easier for parents, client to attend, they don't miss work at school, parent accessibility, pajamas. Personally, I typed in no shoes. Living, convenience, attendance, more participation, efficiency, can represent clients in remote locations, and safety, fewer conflict letters, low barriers to participation, right? All of those things. You guys can keep reading them. That was for the benefit of the folks in the room who can't keep reading them because they're not logged in on Zoom. Let me see if I can't get to a PowerPoint again. The two that I personally identified, I think are summarized by all of the chats. I swear I'm not on that page anymore. All right. Summarized by the chats, we got convenience, right? It is definitely more convenient to log on to Zoom. We also have better participation. Well, I'm going to clarify the word better. We have more participation. Mm-hmm. We'll perhaps talk about what more means as compared to and better, whether it is actually better. Let's go with what are the detriments? What are the downsides? What are the cons of Zoom court? Good. So other chats for the pros were older children more comfortable communicating to the court via Zoom. Let's start chatting up our cons. Less decorum, tech glitches, lack of credibility and formality are the cons. Technical difficulties, lack of interpersonal interactions. Yes, I had so many more pros, I'm a little disappointed. Cons. Last call for cons. The bar section did actually kick me off the internet, even though it says I'm connected. More distractions, can't see body language. Hacks, lack of privacy. Not as much control, harder to deal with exhibits. Yes, parents who live in remote areas, limited to clients who can afford Wi-Fi, can't pay their phone bill, can't pay their electricity, right? All of those things. So let me see if I can't make this.
Yes, sir.
Hello? All right, so some of the current concerns that I started with when I created these, attorney-client communication, right? It is so hard to have a conversation with your client. Where I used to be able to whisper to my client, I'm now trying to text my client on the very same phone that they're allowed into Zoom court on. I can't put my hand on their shoulder. I can't assure them and answer their quick questions while we are in this process. Attentiveness. So we have more participation, as in people are actually logging into Zoom. But what we don't have is actually rapt attention while they are inside the courtroom and paying attention. We have all read the articles about what happens in Zoom school. Zoom court is no different than Zoom school. We talk about the convenience of wearing pajamas, of not wearing shoes, of not, right? It doesn't feel like court. So for our clients, it doesn't feel like court. It doesn't feel real. It doesn't feel as though it has the same professionalism, decorum, right? The sort of everything we know about court that's supposed to send a message doesn't have that same message when it's just another screen that they're looking at. Crowded, right? When I say it's too crowded, I mean, there's a lot of boxes on the Zoom and it's unclear who's talking. It's unclear who's being talked about. It's unclear who's being talked to. I'm sure we have all been in the hearings where somebody has said, is so-and-so here? I can't find them on my screen. Are they, right? Where are they? That's true for our clients. They don't even know who they're talking to. They don't know who's talking. They can't find the judge. They can't make eye contact with the judge. The judge can't make eye contact with them. So there's just this big old screen. And the technology failures, right? All of you have mentioned the technology failures that, right? Are you on mute? Oh, you're on mute. You're trying to talk? I think you're on mute, right? That. I try to make it 4 days in a row without somebody saying, are you on mute? And it is hard to make it that many days in a row without those magic words coming out. I believe none of us have probably appeared in court as a cat, but we all remember appearing in court as a cat lawyer, right? All of those failures.
And I think also just generally, I mean, this is all sort of encapsulated by what we talked about, but sort of the theatrics of court as well. Like, it's very hard for me when I'm making objections to unmute my mute button quickly enough. Also in physical court, you stand and it's a signal for everyone that something's about to happen. In a Zoom court, it's sort of hard to have those physical cues that you're about to do something and then the question has maybe been answered and you can't sort of unring that bell. So I think, that goes to decorum and attentiveness. It all ties together. But really, I think what we're getting at is that this is sort of a new legal frontier in many ways. And we need to think carefully about how and when we're using it.
And I want us to think about our clients when we make that decision, right? So let's not get to the question of it is convenient for us to not have to write conflict letters. It is convenient for us to not have to sit in a courtroom. Are we getting the right outcomes? So let me, a couple of other, problems with Zoom court, and then I'll get to the, what do outcomes look like? Eye contact, I mentioned that already, right? It's challenging over video. We can't see each other. We don't know who we're looking at. Right now I'm staring into space. I have no idea who I'm talking to. I'm staring at a blank screen. Body language, videos don't get gestures sometimes. I don't know what part of my body you can see, but like my hands aren't always up here. Sometimes they're down below. One of my students last year told me that he spent class baking bread. I couldn't tell, which was great, but we don't know what we're doing while we're on Zoom or what we're talking about or how we're actually communicating what's going on. And tone of voice. So I learned this. I didn't actually know this piece of information, right? We all talk about, oh, I hear my voice over a recording and it doesn't sound like me. Apparently that's because recordings are designed to actually filter out low and high pitches, and you lose those, so you get this sort of monotone moment on your video recording, and that's somewhat intentional so that it picks up the right sounds, but we lose it, right? And tone of voice is a large part of how we communicate when we're doing court stuff, right? When we're making an argument, when we're making a passionate plea, when we're arguing for our clients. Witness testimony. What are you talking about?
It looks like child witnesses are perceived as less credible and trustworthy when testifying over closed circuit television than and in person. I don't know if you have anything else you want to add to that. But generally, as well as expert witnesses, they're reported to seem less legitimate, effective when testifying when they're in their home or offices rather than in court. So I think, again, this just goes to when are we using Zoom testimony and what is it taking away from the process of court hearing?
And then there have been a couple of studies. These all predate the pandemic. These are not studies about COVID virtual hearings. But these are studies, and I actually only demonstrate one of them, but there's a similar one on immigration. And the demonstration, the studies that have been done, bail and immigration, identify that there are worse outcomes. I guess assuming you're on the side that seems bail is good, but there are worse outcomes for clients when we are in virtual hearings than what we are in person. This was a surprising outcome when folks were interviewed. When they were asked, do you think the outcomes were the same, different, higher, or lesser? Everyone thought that there was zero difference between the in-person hearing outcomes and the closed circuit virtual hearing outcomes. And they identified that there was an average bond increase of $21,000 or 51% in bail amounts for virtual hearings. Right? The outcomes are not as good. It is not surprising the more we learn about virtual hearings and how things are conveyed when we, you lose the humanity, you lose the human touch, you oftentimes lose the character witnesses and the family and seeing the family around the person and the interaction, which makes it a lot easier to set a higher bail amount. It makes it easier to keep parents separated from their children, whether that be in a delinquency setting in a detention case or in a dependency setting when we're removing children from their parents' homes. Right? I think all of that is easier when we are less human, when we are appearing as a box on a Zoom screen.
Yeah, and I also just want to say that back to that interaction between parents and children, that was always like a key point of dependency proceedings in person. I think it was useful for sometimes a guardian ad litem to observe a parent-child interaction that just naturally, well, I mean, not naturally in a courthouse, but that, you know, those moments of interaction, especially like I don't hide my bias, I'm a parent attorney, those are moments that I use in a courtroom, and we're just not seeing that when an infant is, you know, really not even coming to court and is, you know, not on camera at all.
I've been told, so I am not monitoring the chat. Somebody is monitoring the chat and texting me questions from the chat. So, because I can't get back off my PowerPoint and monitor the chat.
Zoom.
And so I am understanding that there's a question about whether you can record the proceeding and whether any party can record the proceeding in juvenile court Zooms. I think the answer is no. Every Zoom hearing that I've been in has a big disclaimer on the front page of it that says, this is a private, confidential juvenile delinquency proceeding. Not everyone can be here. Recording is strictly prohibited. I think that is the right legal answer. I think, right, not just the right practical, our courts are imposing it on us, but I believe because of, right, court proceedings, you generally can't walk in and turn your cell phone on and hit recording. I think that makes that the right answer. I'm happy to.
But also, I think this is back to some of the considerations, which is that how much do we really know about what's happening around us when we're in Zoom? And I think we'll get to some of that later, both when we talk about evidentiary issues as well as, you know, admonishments that we would look for the court to give.
Yeah, and I'll give two further answers to that. One is there is a uniform rule of court that governs recording of proceedings and who can and how you need to ask permission for it. I've been told over text that the answer is Rule 13. And then secondarily, I was told multiple people over text that the answer is Rule 13. Thanks, guys. And secondarily, I'll say, right, that being said, we have no idea who is recording.
Or who's even in the room.
Or who's in the room. We have no idea what's actually happening, right? We don't know that there's not somebody not perhaps hitting record on Zoom, but turning on their cell phones or their cameras or any of the things. It's a little bit harder to be surreptitious about that inside a courtroom, although not impossible there either. All right. Can you prevent a Zoom hearing? Can you, right? Do you have to show up to virtual court? Can you say, no judge, let me show up in person? So that's 70% of us who are showing up in person.
No, showing up on Zoom.
Showing up on Zoom, 70%, right? 70% of us are showing up on Zoom virtually all of the time. Are we doing that on purpose, or are we doing that because the court is making us? I'll start with a very easy answer. Uniform Rules of Juvenile Court 12.2. A Zoom hearing cannot happen without the consent of all parties, which means you can prevent it at a formal adjudicatory hearing, or at a formal hearing alleging violation of a protective order that may result in the loss of liberty of the alleged offender. That's it. When you have an adjudicatory hearing, you can say, in person, please, and you're done. All others, Emma?
Yes, are permissive, which basically means it's within the discretion of the juvenile court judge to hold any other juvenile court proceeding via video recording. So that gives wide latitude to the juvenile court judge and also to the parties to make any formal request for, I guess, an in-person. It seems like now it's presumptive that it's video conferencing unless you are requesting an in-person if it's not a mandatory in-person hearing. So that is basically all of dependency hearings. So we'll talk a little bit more about arguments to make, arguments of first impression, to handle basically this new method of law.
Notice requirements. There are in 12.2 requirements for providing notice if you want an actual witness, right? It's not just the whole hearing to be in person, but somebody to appear in person. Those timelines are spelled out for you on the slides. I think these slides were provided to you maybe before you logged in. For those on Zoom, everyone in person got to pick up some slides. If they're not, I'll figure out how to get them to you. I got another question, which is, does appearing virtually waive service? No. I think appearing in person doesn't waive service. Appearing virtually doesn't waive service. I think you get to always object to the service question.
But if for any reason you think that that's not the case, then you should never be having a virtual hearing.
Right.
I mean, if that is the practice, and you should be, I think the other thing is that, like I said, this is such a new frontier that everyone should be making a record, a very clear record about what's happening, ensuring that these proceedings are being recorded and documented in a method consistent with the uniform rules of juvenile court, to make sure that, you know, these cases are going to be able to be reviewed by a higher court. So I guess this is Randy likes to say this is the one slide I made. So I think talking a little bit about the right to confrontation in dependency cases and what it sort of means when basically any dependency hearing can be held virtually. So in Blackburn v. Blackburn, state of Georgia said that really these are protected interests in the same way. The right to confrontation is a protected interest in the same way as a criminal conviction would be. A criminal conviction, a criminal trial would have a right to confrontation, but the Court of Appeals has sort of modified this idea by clarifying that it's not necessarily a Sixth Amendment right to confrontation, but it's a due process right, and that can look a little bit different. But the higher courts have applied both the Matthews v. Eldridge test, which I'll talk about in a second, and the Craig v. Maryland case, which is a case involving Sixth Amendment confrontation in the criminal context. So it sort of gives us a little bit of guidance as to how the courts are looking at confrontation in dependency cases and effective confrontation. And I really say this because obviously there are moments in the pandemic when there's such a heightened safety concern that it's sort of presumptive that we need to move to a virtual platform to ensure the safety of all participants. But I think part of this presentation is it's becoming pretty clear that the pandemic is dragging on in ways that we sort of didn't imagine, and that there are sort of these moments when we feel safer, when mask mandates are relaxed, and then there are moments, you know, most recently with Omicron, when you know, it sort of becomes presumptive that large gatherings, indoor spaces are not advisable in light of safety concerns. But we have to remember that there are moments when a blanket rule for safety concerns is not necessarily appropriate. So in those types of cases, you know, if you want to make sure that you're getting an in-person hearing, you want to make sure that the court is engaging in basically a balancing test outlined in Matthews, which is just, in summary, you know, the private interest involved, the risk of erroneous deprivation, and the government interest. And the Court of Appeals of this state applied that test in the interests of CWD. Most importantly, the court adopted the idea that it would be harmful for the child to testify in front of his or her mother, and then the court made you know, tailored methods so that the mother could observe the child testimony via closed circuit television and consult contemporaneously with an attorney. I think the most significant thing here that we're not necessarily seeing is the court engaging in an analysis of why video conferencing would be necessary. you might want to be thinking about those considerations, especially when the pandemic is not raging like it is in Omicron. In the interest of BH, applies similar logic, but look sort of at Craig v. Maryland, and again, noted that there was no confrontation issue because the trial court, again, made a specific finding that there was a need that a child would be harmed by live in-person testimony, and the parent could watch testimony by closed circuit television and run notes contemporaneously to his attorney. Notably in that case, the Court of Appeals found that the child also testified in the presence of the fact finder and was subject to cross-examination in the room by the attorney. These are sort of what's considered like secondary benefits of cross-examination and also critical elements of effective confrontation, which obviously is lost in light of a video conferencing platform. These are things to be thinking about when you're arguing for an in-person hearing, that there are other benefits, not just that you can contemporaneously consult with an attorney and you can observe, the parent can observe the child or any other witness testifying. Also the idea that the child is or not just the child, but any witnesses testifying in front of the fact finder and in front of counsel, because there are those secondary body language signals that Randy spoke about earlier that can't be observed. So I think that there's really a due process question that is ripe to be litigated if you are not getting an in-person hearing, especially in a contested adjudication or termination of parental rights hearings. And I saw that adjudication came up as a hearing that many people are having via video conferencing. So that would be an area to look to. Also, just in my research this summer, when the juvenile court rules were being finalized, there's I believe it's a typo in a delinquency case, which is in the interest of ET, that actually says that the Sixth Amendment right to confrontation, they say this right applies in a Georgia deprivation proceeding. That's a 2017 case. I thought maybe they meant deprivation, like deprivation of liberty, but then they also refer in a footnote to deprivation cases. And they cited a deprivation case calling it that. So I don't know, you might be able to use that to your benefit. And I can send out the site if anyone needs it. The other thing I wanted to generally talk about is a question of abuse of discretion. The uniform rules gives the juvenile court judge the discretion to hold a hearing via video conferencing. And when the court is not engaging in analysis as to why they need to hold a hearing via video conferencing, whether that be because of the pandemic or specific safety concerns of an individual in the case, or harm to a witness, they're exercising no discretion, which is akin to a violation. So I think there's another abuse of discretion argument that is ripe for review when the court is not engaging in any type of active reasoning as to why they're holding a case via a video conferencing platform when they have the discretion to do so. Another question that we sort of thought about was OCJ 1511-700, the accessibility of the public to proceedings and hearings, to what effect that's really being achieved by the video conferencing platform and the notices provided. I also saw in Uniform Rule 12.2, I think it's 4E, the judge needs to be accessible in the same manner and location to the public as if video conferencing was not happening. So that may be something to look at if you think that there is some harm that has been generated by that not being the case. And then lastly, I think also there are some evidentiary considerations about reliability and credibility of witness testimony when we sort of cannot control the environment. The courtroom is basically a controlled environment where the judge, a deputy can control what is happening, but in a Zoom situation, in a video conferencing platform, there's no way to ensure the integrity of testimony, that a witness is not reading or using notes or having someone else provide them answers. And so I think all of these things are elements to consider if you want a Zoom here, or excuse me, if you want an in-person hearing and you're not getting it. These are some potential arguments to make. And really just remember that this is like a new frontier. And so we should be making these arguments when we're not getting an in-person hearing.
I'll just add, right, so Emma gave all the answers on Matthews v. Eldridge and the due process considerations. On the dependency side, I would add that delinquency, certainly on adjudications, we already have the right to be in person, but I would add that detention hearings are equally as important, perhaps more important, right, as the bail study demonstrates. And there might be some due process arguments to start throwing out there on the delinquency side on detention hearings, possibly disposition hearings, although primarily I think the next frontier might be detention hearings. I fear that there's going to be a world 5 years from now, 10 years from now, when Omicron is gone, when hopefully this pandemic is in our rear view, when we are not wearing masks everywhere, but everybody will continue to believe that it is convenient to not transport children from detention centers. And that is a fight that I think is worth fighting. And we should start laying the groundwork for that fight now. I'll throw two new cases, very new cases that came out this year, a couple of weeks ago, maybe a week ago, out of Missouri. These are all in the adjudication front. They were young people in a delinquency case, where, and in two different settings, it was actually the same attorney in Missouri who brought both of these up, where in one of them there was witness testimony via two-way live video, where the court held that violated a defendant's Sixth Amendment rights to confrontation, even though the defendant was inside the courtroom. And the quote of note, generalized concerns about the virus may not override an individual's constitutional right to confront adverse witnesses in a juvenile adjudication proceeding. And then in JAT, the defendant himself was not inside the courtroom. The defendant was on a Zoom, and the court also held that violated the right to due process and confrontation. My favorite quote there are two of them, but my favorite is neither the United States Constitution nor the Missouri Constitution are entitled to take 6 days, right? So to the extent, right, to what extent is an open question. Do we get to extend these rulings, these holdings, right, using the analysis that Emma provided on the previous slide to other hearings, in particular TPR hearings, right? We have acknowledged as a country, as a state, as a people, we have acknowledged that TPRs, that removing a child, that taking a child away, terminating parental rights is a serious
Fundamental
liberty
interest,
as Emma says, that we should be protecting. And so let's start thinking about these arguments. I'm getting notices that my internet is unstable. Again, using our internet, not really sure what that means, but hopefully we don't cut out. So from here, for our last 18 minutes, maybe 10 to 15, so hopefully we'll leave time for some of the questions that I know are coming in that I have not answered. If you're going to do a hearing on Zoom, and I'm not talking about you're going to do a plea, but maybe I'm also talking about if you're going to do a plea, right? If you're going to do a status hearing, some of these slides are equally as applicable. If you're going to do it, how do you do it so that it's as good as it can possibly be? And I'll tell you, I just did I think I mentioned this at the front end, a multiple hour protective order defense with 50 or 60 pages of Instagram messages as exhibits and an interpreter. It was awesome. The hearing officer, the magistrate judge was ready to pull our head out. The interpreter hated us. We learned many lessons. And I'm here to share some of those lessons. Before you start, right? Before you start your hearing, what are the protocols with respect to exhibits? Right? As an initial matter, to the extent that you can agree upon stipulations, you should stipulate, right? If things are admissible, you should all agree that these things are admissible. But then what? And then what is an important moment, right? When you are in person and you are cross-examining a witness and you want to show the witness, or even if you're a staff, let's say we have a contested hearing on direct examination, you mark an exhibit for identification, and when you do so, the judge doesn't see it. You establish your foundation before you get to enter it into evidence and publish it to the judge. What does that look like in a virtual hearing? How does that happen? Do you share the document directly with the witness and only with the witness to establish the foundation and then share screen? In our case, because they were in different rooms, everybody was in different rooms, the judge actually put herself in a breakout room to show the exhibit, then take the exhibit down, then the judge came back, and then we did a foundation set of questions. That is not ideal. I don't recommend that. But we're, right, so figure out that process, right? And we did not figure out that process. This was an unfamiliar courtroom for me. It was an unfamiliar judge. I didn't have much access to come up with a protocol first, but most of us are in the same courtroom with the same judge, with the same parties. Come up with a process. Figure out how you do a mark for identification, show, establish foundation before you then share to a judge. From there, second question, I also did right, the places where I'm doing contested trials on Zoom, protective order defense, suspension hearings. We did a suspension hearing not too long ago where we had a video. And in that video, there's a question of who gets control of a non-static document. Who gets to navigate showing the video? Where you're going to pause, where you're going to stop, where you're going to speed up, where you're going to zoom in. In that particular hearing, they gave us, defense attorneys, the opportunity to take charge and share screen so that we could navigate our own video. But we did talk about that in the front end before we started the hearing, and it's important to know that. Who has control? Does only the clerk have control? Or will the parties have control so that they can manipulate the evidence? Anything to add on evidence, Emma?
No, thank you. Yeah, I think you got it.
I can tell you it was not easy on any of those. I'll go to you.
Yeah, so I think we talked about this before, that if you're going to have to do a video conferencing or Zoom hearing, that you want to make sure that we are trying to control the environment as much as possible. So witness admonishments, having the court let the witness know that this is, a court proceeding, just as if you're in a courtroom, that, they should not be looking at any documents. They should not, unless a lawyer has assisted them through that process, they should not be Googling or, have anyone else in the room with them who is in any way influencing their testimony or providing them testimony. I think that this is back to the question of just trying to make this as formal a setting in the most informal setting possible. And I hope courts are doing this. I think.
I will say that the first witness in my suspension hearing was driving with her child in the car. So I was like, confidentiality? She's like, I have headphones. I was like, but you're speaking out loud. And so I think we're not right. I hope the judges who are on this presentation are all admonishing all of these things. Our suspension hearing officer did not. And then the second witness testified, and I said, just because of the first witness, let me ask some questions. And then by the time we got to the third witness, the hearing officer started asking all of those questions for me. But again, these should be part of protocol. This should be set up in every single hearing, right? The lawyer shouldn't be doing this, right? This should be a protocol that you, your prosecutor, your SAG, your defense attorney, your child advocate, your parent attorney, your judge, most importantly, your judge, gets into a conversation with and has a protocol for the start of every hearing. Part of that protocol, again, in the world of things that get texted to me, that may or may not be in the chat, because now I have like 9 people texting me. Judges muting attorneys. So hopefully part of your protocol is that attorneys have the opportunity to unmute themselves and or stay unmuted during cross-examination, during examination, during witness testimony. I start muted and unmuted, but as Emma said, it's hard to sometimes unmute quickly enough. And so I have taken a practice of staying unmuted the entire time during testimony so that I can quickly respond and answer. And I think that is important. And then if Lori is listening, along with Judges Cole and Crawford, perhaps the professionalism component of attorneys in multiple virtual hearings at the same time can be addressed by your panel rather than ours. For the lawyers listening, you probably shouldn't do that, but I will admit that I have done an IEP meeting on my phone while also being in a virtual waiting room in a hearing in a different place. It goes to the convenience and how present are we really? I think I was present in most of them. For the most part, I was in a waiting room. And when the hearing started, I left the IEP, but but how present are we? We are proving that we can be in 4 places at once as long as we have 4 devices. We shouldn't be.
And also, I just want to say that we've had this happen in a case that I had where, especially when you have a child in foster care who's maybe in a group home, if they're going to talk about the place where they are, sometimes it's not a private setting or there's someone sitting next to them. And so that might be a really good time when we're bringing people into court, that it's not just necessarily just due process considerations. It's also just strategy and what, will help the judge get the most reliable, accurate information in the case. And, lawyers should be forthright about that and requesting in-person hearings when appropriate.
Prep your witnesses. Please prep your witnesses, right? You are not standing next to your witness. You cannot whisper to your witness. I had never in my entire practicing career had a witness or a client show up to in-person court without a shirt. I'm sad to report that I have had multiple young people show up to Zoom court without a shirt. It is not fun to be watching your client get yelled at while they go get a shirt. I tell them to wear a shirt. I promise you I do. But nonetheless, sometimes Zoom court sneaks up on you and you just wake up and you roll out of bed and you're not driving to court where you got to put a shirt on first. So prep your witnesses, prep your clients, prep your parties, prep your caseworker, prep your witnesses. Prep them on how to use the video technology. What are the protocols in the courtroom? Does the camera stay off until the judge turns the camera on? Does the camera always stay on? Do you have to stay mute until you're responding? Probably. You should be in a quiet, private environment. You shouldn't actually be driving your car. You shouldn't be operating in a conducting, I don't know if you all saw the video that went around of the attorney who was actually in the middle of surgery while appearing for his own, I think it was a traffic court citation. You shouldn't do that. If you are going over a case where there are exhibits, you should actually review the exhibits in advance, right? There are things, right? There's additional layers of prep because there's less momentary responsiveness that you can handle inside the courtroom, right? And we all used to talk to our clients before we walked into the door, right? Even if we talked to them the night before, we talk to them again while we're sitting in the hallway, while we're outside the courthouse. Have those same constant communications with your client before your hearing date. Okay. And then communicating with your client. How do you actually communicate with your client during a hearing?
I mostly am texting on my phone, but again, this is, they're trying to listen and you're texting them and they're going off, they're not watching testimony anymore. You can't, it's harder to pause. So, I mean, it's incredibly problematic.
Yeah, if you need to, right? I've done one hearing where I was in the same room. That's rare, right? The whole reason we're not in court is because we're not in the same rooms, and convenience gets eliminated when we're not in the same rooms. So same room is unlikely, but if you can be, it is better. Text is my most common means of communication with my clients during these hearings, but again, they are oftentimes using their cell phone to Zoom into court, which makes texting them just as easy as me reading these chats, which means not at all. So they're just not getting them. Ideally, you'll have a separate means of communicating, a separate open line of communication. If all else fails, if your client starts to say something, if your client starts to have a confused look on their face, if there is something that does not, your client's stuck in some way, right? Ask for a breakout room. Ask to be put into a breakout room so that you and your client can have a actual conversation talking about not a 3-word text. You can't even give a look, right? Because they're not looking at you, right? You can't even, right? You can't glare at them when they're saying that, right? So stop it, ask for a breakout room. And that, we have 4 minutes left, which is less time than I thought I'd give you all, but I'm open to questions. Feel free to write them in a chat. Feel free to, I'm going to take this down so I can see the chats, but also I think you can just unmute yourself and jump in. So if somebody wants to unmute themselves and jump in, go for it. Seeing nothing. All right. Having seen nothing, we will have a 2-minute break while we switch over, or not a 2-minute break. It looks like they're ready. I see people back on the screen. Lori Thomas is going to start the introductions for our Professionalism Judges panel.
All right. Hello, welcome everybody. Thank you guys so much for joining us today. We are going to talk about professionalism in the forever pandemic, through the looking glass of child welfare. I have put in the chat, we're going to do a quick poll. You can join by computer at the link in the chat, or you can use the text feature just like you did with Randy. And that information is in the chat as well. And without further ado, I know that we have our judges here. We are also going to be joined by a third judge, which is always wonderful. If you give me one moment, I will highlight all of them so that everybody can see them. And if the judges will please come on the video. Let's see. Judge Crawford, are you there? Can you hear us? If you can turn your video on for us, that'd be great. All right, and without, like I said, without further ado, I'll go ahead and introduce, we have Honorable Judge Thomas Cole. He's the presiding judge of Chatham County Juvenile Court. Prior to becoming a full-time judge in 2015, he was in private practice in a law firm. He practiced general civil and criminal litigation in state and federal courts. He served as a part-time judge in Thunderbolt Municipal Court and as chief judge of Fort Wentworth Municipal Court and as a pro tem judge in Chatham County Superior Court, Recorder's Court, and Juvenile Court. Judge Cole began his public service as a staff member in the Executive Office of the President of the United States in 1988. That is a fact that I did not know, Judge Cole. He has served as the chairman of the Chatham County Board of Elections, as a member of the City of Savannah Civil Service Board, and as the chairman of the Board of Consumer Credit Counseling of Savannah. As the president of the Catholic Lawyers Guild and in other civic and service organizations. He presides over the Chatham County Family Treatment Court. He currently serves as the chairman of the Nominations Committee and is the member of the Funding and Legislative Committees of the Council of Accountability Court Judges. He is chairman of the Family Treatment Court Subcommittee of the Council of Juvenile Court Judges. He's also a graduate of the University of Georgia, go Dogs, and the George Washington University Elliott School of International Affairs. Welcome, Judge Cole. Thank you so much for agreeing to participate in this panel. Next, we have Judge Honorable Chief Judge Vincent Crawford. He is currently the presiding judge, in DeKalb County Juvenile Court. He is a Savannah native. Hey, so am I, Judge Crawford, and graduating with honors from Florida A&M University in 1987 with a Bachelor's of Science in Political Science. He's a graduate of Walter F. George School of Law at Mercer University. Judge Crawford began his legal career with Georgia Legal Services in the fall of 1990 with a primary practice of representing battered women in divorce proceedings. He joined the DeKalb County District Attorney's Office in 1995 and served as a district attorney for 2 years. In 1997, he began his solo practice. And in 2005, he was appointed to an associate magistrate judge for DeKalb County. He was sworn in as an associate judge in 2006. And he's a member of the Georgia Council of Juvenile Court Judges and the National Council of Family and Juvenile Court Judges. And in 2009, he received the Georgia Department of Human Resources and Youth Empowerment Award, in addition to his receiving the Romay T. Powell Award for the Juvenile Court Association of Georgia for his outstanding contributions and service to the field of juvenile justice. On March 31st of 2012, he received the Recognition of Outstanding Leadership Award from Jack and Jill of America, and he is a member of Phi Alpha fraternity. In 2011, he was appointed chairman by the Supreme Court of Georgia for the Juvenile Court Improvement Initiative. And last but not least, we also have Judge Carolyn Altman, who is joining us from Paulding County. She is a certified child welfare law specialist. She earned her bachelor's degree from Samford University in Birmingham, Alabama, and her JD from Georgia State University College of Law. Prior to becoming a judge, she represented parents and children and served as a guardian ad litem in dependency cases. She also did appellate work in dependency and delinquency cases as well. Thank you so much for joining us, to all of our judges. And I don't know if you all remember who were here with us last year. Judge Altman actually gave it, I think, our professionalism talk last year. So it's good to have you back so we can kind of get a perspective on what you've learned in the last year. And so without further ado, I will invite first with Judge Crawford, if you guys could kind of give us a state of the court for your particular courts. What are you guys doing in terms of how are you hearing things, cases?
Well, it's based on what month it is and where we are with the pandemic. We basically have a court task force which comprises of all the classes of court, and that task force kind of generate, with the chief judge of Superior Court, generates how we actually monitor our activity and go about handling the courthouse as a whole. we did come up with a process earlier on. Now, the interesting thing everybody should know is that when the pandemic hit, juvenile court has always had a virtual conferencing rule. We've always had a rule. It was the other classes of court that were struggling because it either didn't exist or there was no clarity on if they could and how they could do it. But we had that rule, so it was easier for us to transition that following week into that. So the issue for us became one of actually in DeKalb County of how we were going to do this. I heard Ms. Waldman talk about a lot of those things. Those were a lot of struggles we did have in the beginning, getting people on. So what we have now, we have a protocol in place for both in-person and we have for virtual hearing. I will say some virtual hearings, we've learned that probably will stay around, especially with some of the dependency matters, because we have people that are in various locations. We have parents in some facilities sometime. We have gotten more participation from parents in prison by just sending notice to the prison. That's been incredible. And they log on time. And but we've gotten more. That's the thing about virtual, is that we have stumbled into this thing where we are getting more participation from parents and children, agencies, counselors, people are logging on. But we do have an in-person protocol that is pretty much run by our sheriff's department on when we do have an in-person hearing, how people come in. But it is going, I will say, it's not the greatest system, but for some things, it works incredibly well, especially those things where you only need to discuss something for 5-10 minutes and people are not having to pack up, come down to the courthouse, sit for 3 hours to hear a 5-minute announcement. So we are moving along. We're expecting we suspended in-person for the month of January, of course, because of Omicron and the current situation. But we do still have it in person if people want to, but nobody has made that request. And then we will hopefully, starting in February, we will go back to some kind of system, a dual system, or well, our hybrid system of both in person and virtual.
Judge Cole?
Mostly, I think I would just echo what Judge Crawford said. I mean, things are similar in Savannah. Certainly, our bar has gone above and beyond to work with their clients to be prepared for court. But for the most part, our goal is to get back for most things to in person. But like everywhere else, when we feel like we're getting close, we end up taking a step back. So it is amazing and wonderful to be able to see so many extra people. And I guess I'll repeat what Judge Crawford said on that aspect, that normally wouldn't be appearing. And being in Savannah, we're so far away from other big population centers. When I've got a child placed in Columbus, Georgia or Atlanta, and they would put them in a car and drive them 4 or 5 hours for even a permanency hearing, and then drive them right back, I always felt I felt sorry for the child for spending 10 hours in a car for that hearing. And if possible, we're going to continue to give them the opportunity to participate virtually for those. But our court, has protocols in place. We fortunately are lucky to have technology to do our hearings, I think, pretty well. And we're going to continue to do that until it's safe, and then continue to do it in areas where it makes sense and doesn't mess with any of the parties' rights.
And same question to you, Judge Altman.
Good afternoon, everybody. It's good to be here and to be back. And thank you, Judge Crawford and Judge Cole, for letting me crash your presentation at the last minute. And
You're always welcome.
Thank you, Judge. Paulding is we only have one full-time judge, so it's a little bit different than Chatham and DeKalb, and we are all virtual for dependency. We've had some in-person hearings, and that is completely at the request of the parents. So if they elect to have an in-person hearing or trial, we will accommodate that. And we were all virtual with our delinquent hearings up until September of this past year. And then we went back to a couple of virtual hearings in our delinquent cases in January, just kind of depending on the circumstances. We found that particularly for delinquent hearings, it tends to go better in person, that it kind of has more of an impact on them. And also, like for delinquent hearings, you want a one and done. We want to see you one time and don't come back, no recidivism. Dependency hearings, we're going to see you over and over and over and over again for the length of the case. And so it doesn't seem to have such the same adverse effect of starting it off virtual and then setting the expectation that this is probably what it's going to be like for a while. And also our courtrooms are the size of postage stamps. And so having people in there is challenging, and we have some immunocompromised attorneys. And so they have been very engaged with having virtual hearings. And I have no idea or expectation any longer that we will deviate from our virtual platform at all. And when Brandy was asking about some of the benefits of it, I will just say one of the big changes, it's a huge benefit and it's a constraint, is that we have time certain hearings. And so that has improved timeliness and efficiency. It has also meant that we have fewer hearings per day. We used to be able to do 12 to 14, we do 7 now, which means we have more court days with fewer hearings, but that's kind of the trade-off. So that's the update from Paulding.
All right, perfect. Thank you for that. All right, so I just also wanted to, since we have a platform of 110 people here, I also wanted to give you guys an opportunity to talk about any challenges your court is facing. I know one of the things that I've heard from all of you is about the court-appointed attorney list. So I want to give you guys an opportunity to kind of share with our constituents exactly what, any other challenges, as well as any messages you may have regarding that.
I will start with that because I pretty much, with the parent attorneys, I started out as one, and then I started out with the Supreme Court with working with the group in DeKalb that we later expanded. I want to say to everyone, a study was done some years ago, and I'm not sure if it was called Vincent Institute. Judge Cole, you may be, I don't know if you remember, but there was a study done, and I think the Supreme Court got the study on which system works best, because the American Bar Association took on this thing of parent attorneys and creating a section for them. And I went to one of their conferences, and one of the discussions was around these 3 different types of parent attorneys. And one of them is, some jurisdictions it's done through the PD's office. Some jurisdictions, they have a contract firm or attorney, which is a set group of people that actually are under a contract to do it. And then the third type was the solo practitioner that is just on a list. DeKalb, we've always done the solo practitioner aspect of it. It has always been a great foundation for those attorneys going out in private practice to build up a practice of law. I'm not saying, it's an experiment on people, but it's a good, you're learning how to interview clients, you're learning, court procedures and process. It's a very, very good mechanism. And that's what we have always used it for in terms of getting new attorneys on. The issue is that those new attorneys come on, they become your very skilled attorneys, and then their practice expand, and then they fall off your list. Now, in the past, that wasn't so much of a problem because we held a list of somewhere between 50 and 60 attorneys. I don't know if it's because of COVID or what's the current situation, but that list has now declined, where we have about 40 attorneys, and we have them that are called active and inactive. They're on the list, but they're active or inactive. So some of the attorneys have asked to stay on the list, but they cannot accept cases right now. So they're inactive in terms of handling cases, but then there are those attorneys that are active in accepting cases. that has dropped down to somewhere, my secretary said, somewhere between 12 and 15 attorneys. So that's a big drop for us on our list. Now, I don't know what it is. I don't know if it's we don't have a lot of new solo practitioners going out, but all of those systems have a good and a bad point. The bad point for solo practitioners is you do that list, at some point it starts to dwindle because people go out. With the contract firms, it was the issue became that the firm becomes overwhelmed because there's so many cases, and you have 2 or 3 lawyers handling a lot of cases, and it just becomes overwhelming. And then through the PD's office, you have now a smaller number of attorneys that are handling cases, but the judge still end up having to appoint attorneys for the conflicts or for guardian ad litems. We still will be a part of that system with even the PD system. So I think right now that's where we are. We're not sinking. We're still above water. But I think for all of us, Judge Cole, Judge Allman, all over the state is having the same kind of issue, is that recruitment for people to do this kind of work. I'm a former defense lawyer. It's like being a public defender, because a part of this work has a social aspect to it, social work aspect as an attorney. And I heard Ms. Wallman talking about it earlier, prepping your client for a whole lot of things. Are you going to have clothes? You're going to have a ride to the courthouse, all of those kinds of things. But that's my take on it.
Judge Cole?
Yeah, I want to ask first, Judge Crawford, what do you all pay your panel attorneys? Is it 45 and 60 or?
Oh no, I had to up it.
All right.
I had to up it because that was one of the things. So I upped it to, I think, 50, and I think it's 75.
Right.
So we had to up that. And let me tell you also, I had to recruit pro tems. I had to up the money for pro tems as well, because we needed 4. And so getting attorneys to do this work, it was like, okay, well, you got to give some more money. But I want to say this, Judge Cole, it still didn't attract an overwhelming amount of people. The people on the list were thankful, but it didn't attract an overwhelming amount.
Yeah, I think, and Chatham has one of the biggest challenges in Chatham right now is the number of attorneys available for cases on our panel. And I mean, I see we have a bunch of our lawyers on this in this session as well. But relative to the number of cases we have and the number of courts they need to be in, there's a real dearth of available attorneys. And I think if we raised it just a little, like Judge Crawford did, that's not going to bring other people in. And part of what's most important, I think, is that those that do participate in juvenile court also have that expertise, because it's not just a warm body that we need. We need somebody who knows and understands the services that are available, that knows obviously the legal process, but understands child development, understands, substance use disorders. I mean, all of the different aspects. And so we're actually working right now to get the county to change it more substantially than that, because our competitors are the federal district court, which uses a panel in Savannah. They don't have a public defender in our federal court, and they pay $152 an hour. So if you do criminal work, you can go get $152 an hour in federal court. And then our neighboring counties all pay more. Some of them pay $100 an hour, and some of them pay, $65, but pay from the time they drive out of their driveway to the court, a county away. So money is obviously an element of it. But the one thing I do note, and it ties into the professionalism, is the lawyers that do work here regularly really care about this kind of work. They care about the families, the children, and they're clearly doing it as a calling. As even for judges, You know, we could make more money in private practice, but we do this because we care about this work. And the lawyers that come to our court, even though they should be paid 3 times more, obviously care about the work. And that shows. That's part of the professionalism, you know, that we see regularly, is they're putting the interests of the client and the profession at the top of their list. So thank you.
And Judge Altman, for the sake of time, I'm going to skip you on this particular question, and I want to just jump right into the professionalism. And so I did ask everyone that wanted to participate to jump onto the poll. And the first thing that we're going to kind of talk about is we're going to, the question was asked, what is professionalism? And so you guys responded. Thank you for your responses. And some of you guys said it's responsibility, it's respect, it's adulting, it's being organized, being honest, courteous, having integrity. Respect seemed to be the number one thing. Having accountability, and definitely having competence. And that kind of goes to Judge Cole's comment, which was, we don't just want a warm body in the courtroom, we do want someone who is competent as well, because that is not only required under our ethical rules, but it's also a part of what's important for our profession. So let's see, we are moving next to, I will ask you guys a hypothetical. And it says that the first hypothetical that we have for you guys is, as a new lawyer, you quickly signed up for to accept a court appointment. However, you now begin to wonder about the wisdom of your action. The court just asked you to represent an accused child abuser. Should you turn down the appointment because you do not want to be associated with the accused child abuser? From a judge's perspective, if you can provide a idea of to our bar what they should do in that event. We're going to start with Judge Altman.
So one of the good things about being a court-appointed attorney is that you don't get to pick your own clients. So there is no taint of association. You get the client that you get, sort of like, you know, the hand that you are dealt. So there is no personal aspersion or connection if you are representing an alleged child abuser. I think what I thought more about with this question, though, was if you are a brand new attorney and you've never faced this overlap between possible criminal charges and a dependency case, maybe you shouldn't accept this appointment, not because of the reputation that you think you might incur, which you won't, but because you may not actually be qualified to handle the complexity of this particular case. And I will say that I had an attorney one time who got appointed on a case and then corresponded with the clerk's office and said, I don't think that I can handle this client. And I thought, I really appreciate that honesty. And we found somebody with more experience, because that goes to the issue of competency, that in this particular matter, unless you have somebody that you can associate with, this may be over your skill set at the moment. And unless your skill set grows, you could be doing that client a huge disservice.
Do either of the other judges have anything to add to that? I think that was a great response. Thank you.
Yes, I would just say this. One of the things that we attempted to do a couple of years ago, and this was before COVID, is the new attorneys go on an observation list, but then they are matched with a more experienced attorney. So we have like a mentoring going on to make sure that they're comfortable with things. I did have that situation come up with an attorney, and one of the other attorneys, one of the most seasoned attorneys, was able to guide that attorney through what was happening, especially when something occurred in court. So I agree, but I don't like attorneys to be in a situation where you're now gauging your comfort with your legal representation, and those two are at conflict with each other. And so that one will, that conflict at some point may become too overwhelming to a point where it impacts the way you represent the person. But I also do agree with Judge Altman, especially when you have that dual representation, because you are quasi representing them if they're charged with a criminal matter, to make sure they don't say anything in juvenile court that gets them in trouble in criminal court. So yes, we do it through mentoring.
And I'll also say, as a practitioner, you know, we have a duty. It's not ethical or what or otherwise. It's really part of our professional duty, our professionalism duty, to recognize what some of our traumas or our triggers might be. And because of the work that we do can be so trauma focused, that if we get appointed to something that might trigger us or provide us any type of a trauma, that we need to make sure that we take a step back from that matter. And you can do that in a very professional way by just letting the court know that this is not a matter that you can assist on, and you may need to ask for, and it needs to be reappointed. Most judges will understand that if you're not doing it on every case, that this is something that's important, you know, or there's some valid reason as to why you can't do that. And those who served on the court appointed list have probably had to do that at least at one time in their careers. Moving on next to let's talk about flexibility and what the meaning of flexibility is and professionalism when we talk about being in the forever pandemic. We've talked about already, like virtual hearings and things like that, and Randy and them have kind of touched on kind of where to attend those virtual hearings. But just from a judge's perspective, what have you seen to be a don't in regards to attending virtual hearings by either parties or attorneys?
A moving car. Do not attend a hearing in a moving car, and never, ever, ever, ever be the driver of a moving car in a hearing.
And the same applies. The judge should not hold hearings while driving, right? So,
Yes,
I would hope not.
same for
I heard
judges.
yes,
I heard there was one time a practitioner who was standing in line somewhere and was participating in a hearing. And the judge kind of called the hearing at that point as soon as they recognized that they were standing in line in a public space. Randy mentioned there was a doctor who attended a traffic court hearing, and he was literally in surgery during on video during the traffic court hearing and the judge immediately called the hearing and said she wasn't comfortable proceeding forward because of that. So that's
I just
definitely.
think of it. I'm sorry. Go ahead.
No, go ahead.
No, I just think of it in terms of we've had 2 years to make this adjustment, but and so people have forgotten about what it means to be in person. But how would you conduct yourself if you were in person? I heard Ms. Woman talk about someone, you wouldn't show up to the courthouse with no t-shirt on. You wouldn't show up inappropriately dressed at the courthouse. You're not going to drag a whole group of people with you into the courtroom and carry on a conversation with them in the background while you're actually in court. So I think some of it is just thinking in terms of I'm present in a court proceeding, and that's where people, I think, it just kind of falls apart, is grasping that you're still in a court proceeding where a judge is taking evidence and there's testimony. You're still in a court proceeding, and that's where I think it kind of falls apart.
yeah. And lawyers already have so much they've got to focus on and worry about getting to come together for a hearing. But one of them really is that prep of your client. And
yes,
I know that probably most times they do address it, and clients just don't seem to grasp or follow the directions or advice. But just like in court, how a person behaves, that's part of what the judge sees, and it can affect how they decide things. So you want to prep your client thoroughly.
All right, and here we go. Here's a hypothetical that kind of ties right into that. Your client attends most hearings on the case you're handling for him. At the last hearing, your client's emotion apparently got the better of him, and he used various facial expressions to express displeasure with the court's adverse ruling. What should you do?
I would say buy them a bigger mask, right? You know, but professionally, you counsel them, you counsel them, you counsel them, you practice. And that's the best you can do.
In the moment, Judge, they're doing it in the moment. And we know that you see it. We
I'm sorry.
absolutely do.
Yeah. Then you ask for a recess. Judge, I need to take a minute, is what I would probably do when I was practicing.
Yeah, I agree with Judge Cole. The attorney, it's kind of hard for them to focus on the proceedings, making, objections and all that. And then you got a client in the background. Now I had this actually happen. I had a mother having a breakdown, literally, as the whole crying, sliding down the wall, the whole nine. And so I had to stop and let them adjust that situation, because we couldn't continue with her with it. It wasn't, we didn't hear it on audio, but you could see it. But I think the attorney, in monitoring the client, should just say, listen, Judge, can we have a breakout room for a minute? And just put them in a breakout room. And that's what we've done. Just put you in a breakout room. And, they give them the heart to heart and say, listen, we are in a court proceeding. And this is the way you really need to conduct yourself.
What are y'all's feelings on, I'm sorry, Judge Altman, go ahead.
No, I was just gonna say that I think, if it's not audible, it's not Judge Crawford's situation, but if it's not audible, I mean, people don't have to agree with my decision. In fact, most of the time they don't. So I would expect some exasperation or some, facial reactions. I'm not flustered by those things, especially if they're on mute. And so the other thing for attorneys to advise their client is just keep yourself on mute. And then quite frankly, they can mutter, they can do whatever they need to express their frustration in a way that's not disruptive.
Yeah, I agree with Judge Alt. Yeah, we've been all cursed out on we've all been cursed out on mute. I'm sure of it.
Yeah. What do you guys think about lawyers attending multiple hearings at the same time? Is it possible?
No. No. And part of it is, and we try to get attorneys. I love the time certain hearings. I don't think I ever go back to a time. I was doing it before, I started it a little bit before COVID, and when we were doing the in-person, and I think the virtual conferencing has really taught me that it is great, because everybody knows when they're supposed to be there and nobody's waiting 3 or 4 hours. The problem becomes when you have an attorney that has scheduled 2 things for 10:30 and everybody's ready in your case to go, but they have to go make an announcement on another case, and that announcement turns into something longer, which means now my 10:30 case, the clock is ticking and is moving towards my next scheduled case. And so it throws everything off. That's my only problem with it, is especially if it's something where you're going to actually be presenting something and you're going to actually want to talk. I just think it's a little unfair to the other attorneys to schedule 2 things at the same time. When in fact, if the court is ready and everybody's ready on that one thing, you got to go off to something else, make an announcement and be caught up in that. And nobody knows how long you're going to be gone.
What about the cases that aren't at the same time? So we've got something at 9 o'clock and we've got something at 10:30, and we're now bumping into those. How much, I know that, attorneys should file conflict letters, right? But that 9 o'clock case was only supposed to be 5 minutes. So how, should we do them every single time we have cases back to back like that, judges? Or should we, what should we do? What's the best, best way to be professional?
I'm guessing the answer is not to be on 2 hearings at once, right? That's the point of the hypothetical.
I would definitely agree with that.
Okay. But it's hard. I mean, and that's part of the Chatham challenge is we have 3 courtrooms, limited number of lawyers. 1 lawyer is in courtroom 1, and that hearing goes long, which then messes up courtrooms 2 and 3, which then mess up everybody's schedule for the rest of the day. And it's a real challenge. But no, I don't think there's an expectation if the times were sufficiently separate that it wasn't expected, then it's just communicating with the clerks. And it's unfortunate, but we all face that, I think. I don't think a conflict is necessary.
And I let the lawyers, now let me say this, out of deference to the attorneys, I let them set the date. So, and so you are aware of what you have. And sometimes a lawyer will say, well, Judge, I have this. It's just an announcement, or they pretty much know what's going to happen with that case. I can come to you first because yours is going to be shorter and then go to that, or I can go to that first. And that I don't mind because it's something maybe just an announcement or just an update. But if you got an adjudicatory at 9, and you think it's going to be short, the 2 people you don't get a microphone to is a lawyer and a preacher, but because they both like to talk. So the thing about it is you just got a problem there. So unless you know that, this is really short and this is all we're doing, I wouldn't suggest doing it.
All right. What should lawyers do in the event of a technology issue? You're in the middle of a hearing and all of a sudden your technology goes out.
I will say that happened to one of my attorneys who also had 2 people in their office, and all 3 of them disappeared from the screen at the same time. I was very certain something had happened to their internet connection, and we waited because I also assumed, and correctly, that the attorney was kind of in a panic trying to figure out what was wrong with their internet and getting everybody reconnected. So we just paused the proceeding. And I think the question is for attorneys, like, is this an isolated incident? Is this something that happens regularly? If you're going to do virtual hearings, it's incumbent upon you to have a decent internet connection. To the best that you can do this. Like, if a place in your house doesn't work or your office is better, like do that, get there. The other thing is, if you have to come up to the courthouse and just set up in a conference room, then do that. But it's particularly for the attorneys, like, you have to make it work or get whatever device you need to, this is your job, right? You can't just be like, oh, I can't make an accommodation for this. And that's for the attorneys. I think that the burden is so much higher on that. And if there is a problem with the internet, then you start calling in. Zoom has all of those links that you can just dial in instead. So if you can't be there on camera, dial in, email, I'm changing devices. It's maintaining that communication.
I will say, as a practitioner, I bought a brand new computer because I knew I had all this virtual stuff. A week after I bought the brand new computer, the sound and the microphone all went out on it. I went to my backup computer that I thought was still working, and that the sound would work, but not the microphone. And I ultimately ended up having to call in on my phone for every hearing and use the video on my new computer until I had an opportunity to get the entire system completely wiped and rebooted to get everything going again. So, at this point, I've learned to not only have a computer, but at least 1 to 2 backup devices, whether it be a tablet or a phone. And especially if I'm on my phone, I try to make sure that the judge knows that there may be some, difficulties with staying on camera because I'm trying to hold the phone or take notes or something of that nature, or make sure that the phone's in an appropriate place. So again, totally agree with you, Judge Altman. Communication is super key in that, but also having multiple devices so that you do not slow down the progress. When it comes to filing continuances in court, and of course there are rules that kind of go to this, and there's case law that says what is a reasonable continuance. How much, from a professionalism perspective, how much kind of leeway should you as an attorney give to opposing counsel when it's for personal reasons?
I'll just say, when it comes to continuances, of course, my initial reaction is I'm always leery of granting continuances. And so that's where I start with that issue, because I think the children, the families all need to have their hearings. But if you're two counsel dealing with the question, for me, it's always, how do you want to be treated when it comes back? I think respect was the big word on the poll. And when I have something special or something essential with my spouse, I'm going to be reaching out one day, and I'm going to want them to be considerate of my request. And so I need to do the same for them. That communication, and I think you said the word a couple times, Ms. Thomas, earlier, communication is key all around. But just remembering too that we want to treat people how we want to be treated.
And if I can just add to that, there is nobody that I know in my personal or professional life who isn't dealing with something going on. And and my husband works in the mental health field, and the increase of suicidality and depression and anxiety is off the chain. And we had a situation arise not too long ago where somebody had an emergency, and they were scrambling to find somebody to cover. And I thought about it, and I was like, no, even if they find someone to cover, like, their phone is going to be blowing up with, hey, what about this case? What about this case? What do you want me to do? What do you want me to say? And this one person who's trying to deal with a personal emergency isn't going to be able to do it. And we just canceled the rest of the hearings that day. Now I hear what Judge Cole is saying, like, we don't take that lightly. The work that we do is so important. The families that we serve are so important. We don't do this lightly. But there are some times when we, as the professionals, don't model. We have to be able to take care of ourselves so that we can take care of our clients. And we tell our parents, you have to be able to take care of yourself. You have to be sober, your best possible self, so that you can take care of your kids. And then we go in and we're distracted and we're worried and we're not paying attention and we're not giving our best. And what do we just model to everybody else and to our colleagues and to the court? And so I suggested to sort of all our dependency attorneys, if you know you're not at your best, find someone to cover, ask for help. And if you can't find someone to cover, then approach the court and say, I'm here, but I'm not okay. Is there any way we can continue this? Because I think if we're honest, really honest, which, lawyers don't like to be, because we all we're professionals, we're tough, we can do this. But if we're honest, I think we've all had those days, those moments, those times where we've shown up and we shouldn't have. We weren't good, we weren't right. And we tried to bulldoze through the work, and it wasn't good, and somebody else could have covered it. Or it was something that didn't have to be heard that day, that moment. So tag out, please. Tag out so that it doesn't become worse, and make it worse for the clients too. And that's my opinion, but go ahead, Judge.
Yeah, I agree with you, Judge Altman. I think self-maintenance, I call it, is a very good thing. You got to remember, in juvenile court, we're handling As Judge Nash told me, we're handling other people's trauma, which can impact you. For those of you that don't know, Judge Nash suffered from depression. He was a juvenile court judge, and he actually did commit suicide. And one of the things they talk about right now with judges even is our self-maintenance. You got the one trauma that you're hearing. We're hearing 15, 20 cases, a week of trauma and what people possibly have done to children. So I think self-maintenance and that checkout time, if that somebody has something personal, I will say the attorneys typically do a very, very good job. I think communication is the issue, is the key here, as Judge Cole says. Say, listen to the other attorneys, I got this going on. I got this coming up. Do you all mind if I continue the case? And most of the time, other attorneys will say yes, because I think it's one of those things, as Judge Cole says, what if it was me? Would I want somebody? And I think just getting a continuance instead of trying to get someone else to cover, because the client, another attorney shows up and they're like, well, who are you? I didn't talk to you. Did they? And then they start grilling you. It just calls for just a bad situation.
Absolutely. And in the materials, you'll also find that one of our topics is wellness and professionalism, because that is a topic to be discussed in professionalism. The State Bar of Georgia has really had a big push in recent years, I guess, in the last couple of years for wellness and making wellness CLEs a part of the allowed CLEs that we can participate in. And so I'll take this moment to invite any practitioners who might need it to check out the Georgia Lawyer Assistance Program. I posted in the chat the information for that, the link for that. The bar will pay for 6 sessions of counseling minimum, and it can be extended if necessary if you find yourself in a situation where you do need to seek help. And there is nothing wrong with that at all. One of the quotes that I have in my materials is that for too long, the legal profession has turned a blind eye to widespread health problems. Many in the legal profession have behaved at best as if their colleagues' well-being is none of their business. At worst, some appear to believe that supporting well-being will harm the profession's professional success. Many also appear to believe that lawyers' health problems are solely attributable to their own personal failings for which they are solely responsible. And I urge you all to not take that perspective. If you see a fellow colleague or a fellow practitioner having some issues, and you remind them that that there are assistance programs out there. And the last quote that I have in here in the material is that a tree with strong roots laughs at storms. And I think that that's a really, really great quote as we start to kind of try to move forward. Thank you guys for your perspectives on that. That's very appreciated to have that support from the judiciary. When we start to talk about what else we have to do professionally, can we talk about how we should be referring to clients and children and parties in dependency and delinquency cases? So how should we call the mother? Should we call her the mother? Should we call her by her name? What do you guys require in your courts? Judge Altman, we'll start with you.
Always use names. It's okay to use the mother, the father, the child in a written order, but don't do that out loud, ever. It's rude. We have tons of cases. This family only has one. And how do we differentiate and treat people with respect and dignity if you can't even know their names? And quite frankly, if you forgot their names, take all of 2 seconds, look at your piece of paper, your file, your calendar in front of you. It's written down. And then say, Mr. Cole, Miss Thomas, Mr. Jones, Miss Burton. How is Karen doing today? What is Tanya struggling with at school? What does JP love to do as an extracurricular activity? This is highly personal work for the families, and we can't just become abstract files, cases, numbers, mother, 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 father, 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 and just, you know, if any of you have kids, how many of you get tired of hearing mom, 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 mom? Well, as judges, if you hear that all day long, like it makes my head explode to hear the mother did this, the mother did that, the father did this. Their names, their people. And if we abstract by calling them by titles, we do a disservice to the families.
And frankly, if I hear an attorney referring to his client as the child or the mother, it does make me wonder, is this lawyer actually fully prepared and ready to go forward? You know, Judge Altman talked about taking 2 seconds and looking at your documents. I mean, I would hope that every lawyer would know a lot more about their client and be in a position to call them Ms. Jones or Mr. Smith and not even need to look down for 2 seconds. But again, that's what that signals to me, is that the lawyer's not really fully prepared or hasn't done their due diligence in advance.
I'm one where especially if there are multiple, like fathers, multiple children, I like the dual, the child, then their name, or the father, then his name, so we know exactly who we're talking about, especially in the virtual atmosphere. And we have, you know, I'm looking at a name on the screen, then I know who we're referring to. But just to say the child or the father, that doesn't give me anything. But then I know their relationship to the case, and what aspect, and as well as, oh yeah, the mother, but what's her name? I think that's very, very important to actually be able to state that. But if there are multiple fathers or multiple children, just saying Jane Doe isn't going to do very much for us for the record. The same, the child Jane Doe is one of the siblings, but she does want this, this, and this. So that's just the way I kind of look at it.
Thank you so much for that. In regards to, do you guys have any tips, any do's or don'ts as it relates to professionalism regarding cultural or language considerations and effective communication? We heard Randy talk about how she had an interpreter in her last hearing. What are some things that we could do to make sure that cultural and language considerations are given for we're providing professionalism in regards to those things?
I want to ask the other two judges, do you provide the attorneys with interpreting services to speak with their clients outside of court? Because that is something they used to speak with their clients most of the time when they got to the courthouse, but now we're finding that we've had to allocate money for translators outside of court. Judge Cole and Judge Altman, are you all finding yourself in the same situation?
You mean not just Google Translate?
Right. Yeah, we use the professional.
I had a hearing today, and I reminded the attorney that if he needs if I would expect him to talk to his client who didn't speak English, and have an interpreter there, and then if he had any trouble getting the interpreter lined up, to let my office know. So
Yeah.
I would expect that the county would do that. And if there's a problem, I think the judge certainly can order that.
We've increased our budget to actually do that, so that that more attorneys, because you know, it's one thing when you got a client that does speak English, you're able to get on the phone with them, you're able to communicate and prepare for the hearing. If you got a client that doesn't speak English or whatever language they speak, and you can't talk to them until you get to court, then it holds up everything, because now you got to put them in a breakout room to talk before court start with an interpreter. So that's what we're doing now.
Well, and I would say the same thing is that, you know, if we have an interpreter, we need to almost double the time that the hearing will take, and not just for a breakout room, but because, you know, if you're doing consecutive or sequential translation. It's going to take longer. And quite frankly, even if they're doing simultaneous translation, it's still going to take longer. But I will say for attorneys, if do ask your courts to pay for translation, because that's part of your preparation. So even if you've never done it before, even if the judges have never heard about this before, go ahead and ask for it, and then go ahead and ask for it again. You know, you can't sufficiently prepare or meet with your client without having a translator there. You know, Judge Crawford, Judge Cole, and I would be willing to pay for it. But if you're in another jurisdiction that they'll say, no, we'll just keep asking for it. Because I think there's a due process concern there. If you can't have effective communication with your client, and go ahead and raise that and keep doing that, or just saying that I'm going to need to come an hour earlier and have the translator there meet with me. That's how else are you going to communicate with them if you can't even speak the same language?
Yeah, I agree. I agree with Judge Altman. The thing about it is just let the judge know. Judge, I have not had any prep time with my client because it's my understanding there's no payment for a translator outside of court. So I need some time to speak with my client before we begin. I mean, for a judge, it makes things go a whole lot easier for me. And I could probably just call it Judge Altman is ready. If there's as much prep work has been done before court than waiting to court time to now handle all of these issues. And so I think what you're basically saying to the judge, things will move a whole lot smoother if I can do these things before court versus waiting on the day of court. But it's going to happen because you're going to get reversed if I stand up and say, well, Judge, I can't do this because I haven't conferred with my client. And I say to you, well, we're going forward anyway. So I just think that's just, as a judge, we got to work it out.
And because one of in the paper that I put together as well, because the lines of our professional lives and our personal lives have seemed to kind of cross paths, I want to address this before we go out. We only have a few minutes, so if you guys could give us some any quick do's and don'ts on social media friendships and posts, because a lot of us are friends with judges and other colleagues, and sometimes former clients. So if we could have some quick do's and don'ts on that. Judge Cole, I'm going to start with you.
You know, for social media, you've always got to be cautious. I mean, I think there have been rulings, and unfortunately, you have to actively monitor those things to make sure that you don't cross any lines. Judges talk about that at our sessions all the time too. Social media can be tough. You just have to be actively monitoring it. It's the shortest version of what I would add.
Thank you. Judge Altman?
Oh yeah, don't post anything that you don't want to have come back in court or anywhere else, or that you wouldn't want somebody else to read. And be mindful of who's on your friend list. You may have an intended or unintended audience member if you're voicing a lot of frustration. And I will say that in some other instances, I've just looked up articles for judges and attorneys on how to, for a judge or an attorney on how to handle social media content. There's actually some really good articles about it. I will say for judges, it tends to be like you either have to be massively permissive, like be friends with everybody and kind of disassociate, like this does not mean that we have any sort of other kind of relationship, or you have to be incredibly exclusive and just have a very, very tight group, no public posts or anything like that. And I think the same would go for attorneys of you are either going to be really broad or really narrow. And the more broad you are, the more neutral all of your content should be.
Judge Crawford, any suggestions?
Yes, and it's for me, it's how you use social media. I don't use social media to talk about court. My mom said something to me. She is 82 years old, and all the other relatives in the family were like, well, we like to call her and all this. And I was like, okay, I'm gonna get you a Facebook account. I created a Facebook account for her. And then she goes on and she goes, oh my God, why are these people saying all these things about their life? They're telling all their personal business. And I was like, yeah, and you keep reading it, right? So the thing about it is, I think how we use social media, and I use it basically for updates on people and what's going on, birthday celebrations, great things going on in people's life. And then I do the same thing. That's what I post. Or if I want to post something encouraging to somebody or something like that, I think we have to just, what are you using it for? Is you got to ask yourself. And but I think putting a whole bunch of information, because as judges, we have to also maintain this barrier of of not showing bias or giving our opinion on everything. And so I look at some posts, I have an opinion, but some things are better thought than said. So I just read it and I go, okay, well, I disagree with that. I don't feel the need to pick my phone up and respond to it. So that's one of the things I just follow my dad's advice. Some things are just better thought, son, than said. So
I want to thank all of you all for agreeing to participate in this session. It's been very eye-opening and very informative. And with that, that concludes professionalism in the forever pandemic. And I will turn it back over to our wonderful chair, John Paul Berlon.
Thank you, everybody, for your time. Thank you, judges, for donating your time today. And nice to see other judges also there online and joining in. So many thanks. And again, please reach out to the section how we can help support you. We want to make sure we're in all four corners of the state. So if there's something we can do, please let me know. Thank you so much and have a great day.
This concludes today's meeting. Thank you for joining and have a great afternoon.